like to call our Newberry County Council work session to order. First item up is a review and discussion of proposed revisions to the Newberry County Employee Handbook. Ms. Winters.
Thank you, Mr. Shealy. You have in front of you a draft of the Newberry County Employee Handbook. Fear not, we're not going through this all tonight. I know you're disappointed, I'm sorry. I'm gonna hit the high points, and my thoughts are, and certainly council can guide me otherwise, is we'll just give a broad brush tonight of what I feel are pretty salient policies that are in there, some of the changes that we've made. And then you have probably 2 meetings to actually read it. I don't anticipate that anybody's going to read it cover to cover. Now, Mr. Reader may, because he's almost an attorney and he may want to do that. And I would welcome anybody to do that. But if you don't care to read the whole thing, I don't think you want me to stand here and do chapter and verse in 2 weeks. So I will do the same thing in 2 weeks. I'll just hit the salient points, the ones that are significant, unless you have specific questions or a specific policy that you want me to address. Does that work for council? Okay.
Great to me.
It's my understanding that your last employee handbook was passed by resolution. That being said, it's much better to pass a handbook by resolution because when laws change and we get case law, you can amend the handbook very quickly and not have to do your 3 readings, public hearing, and all of that. And it's acceptable under state law. So if you're okay with that, I will prepare a resolution as well for our final handbook. Okay, so the first page, and again, I promise you I'm not going through this page by page, but the first page is significant. It's a disclaimer, and it stems from a law that was passed in 2004. If anybody actually wants to look it up, it's 41-1-110, and it is the at-will legislation. Won't give you the history on how it came about, but it is at will. I'm going to give you a little bit of, I'm going to go lawyer on you just a little bit. And most of you know I also in another life was an HR director, so I'm going to mesh those 2 today. So I hear the phrase a lot, well, we're a right to work state, and so we can fire people because we're a right to work state. A right to work state says that if you work for a union organization, you do not have to join the union. That has nothing to do with at will, okay? So in Philadelphia, New Jersey, New York, if you work for a company that has a union, you have to join the union. In South Carolina, if you work for a union like VC Summer, I think they are union, or they were almost, is that Mr. Johnson, I guess?
They were for a short period of time.
They were, and I did some anti-union campaign for them many, many years ago. But if you work for them, because we're a right to work state, you don't have to join the union. You get the benefits that they sort of beat the company up on, and so you get those benefits, but you do not have to pay union dues. You do not have to be a union member. You live in New Jersey, that is not the case, okay? So right to work is not a phrase that we normally should even be talking about. At will, however, is. So our employees are at will. That means, in theory, that if I want to fire Mr. Reader, I can fire him for any reason, a bad reason, a good reason, or no reason at all, as long as it's not illegal. So I can fire him because I don't like the color of his shirt, which isn't true, but I can't fire him because I don't like the color of his skin. Does that make sense?
Right.
Okay.
I did it anyway.
But but it doesn't work in reality, okay? So if you're in front of a hearing officer for the unemployment office, if you're in front of a judge, the Equal Employment Opportunity Commission, they want a reason, and at will isn't going to fly. At will really isn't a reason to fire somebody. I always tell people it's not a sword, it's a shield. It protects this handbook. It tells people that this handbook is not a contract. Don't rely on it. This council can change it at their pleasure. And so this disclaimer in the front is required by state law. It's required to be conspicuous, and that goes back to 1986, a very old Springs Industries case that requires this to be conspicuous. The law also requires it to be underlined. Chester County can take credit for that. The senator at the time thought that underlining would make it more conspicuous. Has to be on the front page of the employee handbook. Okay, well, that's problematic. Who has the handbook? The employee, right? So we don't have any proof that the employee signed this. So we will have two. One will remain in the handbook and then one goes in the personnel file. But it clearly states that I understand this is not a contract and none of anything that is said to me or done with me is an implied agreement or an implied contract unless I have a signed document that's a contract that is approved by this council. Okay, and so the employee signs it, and then that says we are not, this is not a contract. Then I would, there is a special note. See if I can find it for you. Sorry, I had all this tabbed and I dropped it. Yeah. We have a special note. It is buried in here somewhere. Anyway,
Page 4,
page 4. Thank you. Mr.
in green.
Cease. That's it. In green. You have one in color. Anyway, it says, we're trying to eliminate cumbersome reading. And so instead of having his, her, him, her, she, him, we just put a special note in the handbook that says we're using the masculine pronoun. It applies to everybody. It's not a statement of anything other than brevity and just ease of reading this. We always have an opening statement from council. If council wishes to rewrite what's in there now, I would welcome that. It's a new council. It's a new day. We've kind of come into a different era with y'all. Elected officials, I also recommend that we put language in the beginning of the handbook because our elected officials are not subject to this handbook unless they want to be. Elected officials and their employees, also appointed officials. But some elected officials do want to adopt the employee handbook. Some like to just pick and choose what policies they want. That's okay too. But if they adopt the policy, we would like to know that. For example, if, let's say, the clerk of court adopts the policy handbook, one of her employees wants to file a grievance, Catherine Cook needs to know that. Somebody comes and files a grievance, she needs to know that that's a valid grievance, okay? So the elected officials do not have to sign it, of course, but they also need to remember that one cannot bind an incoming elected official. And so if the clerk of court were to sign it, adopt this handbook, and then we get a new clerk of court, the new clerk of court would have to decide whether he or she was going to adopt the handbook. Okay, make sense? Equal employment opportunity. This is a word that's kind of bandied around a lot by folks that very uncomfortably don't believe understand what it means. This means our door is open to everyone, no matter who you are, okay? The policy is driven by its very old law. It's the Civil Rights Act of 1964. Hear that, 1964. It's been around for a long time. We're in 50 plus years. Title VII's been amended over time, but essentially what it is the bundle of employment laws that drive us as an organization with employees. In October of 2021, the state Supreme Court issued a ruling stating that Title VII protected the LGBTQ community. Prior to that, they did not. So what's protected under Title VII? The protected classes include race, sex, disability, religion, help me, genetic information, color, which is different from race, okay? Those areas are protected. So folks that are in those protected classes, they have rights under Civil Rights Act, under Title VII. In October, when the United States Supreme Court ruled that LGBTQ was now protected by Title VII, that means that the folks that are in the LGBTQ community, gay, lesbian, transgender, they are protected from discrimination. Now, that's a ruling from the Supreme Court. That's not black letter law. That's just, but it's a ruling from the highest court in the nation, and so we have to adhere to that. We want to adhere to that. It's a protection that's been extended to this community. And so we have we sculpted this policy because of that. The earlier section also referenced labor organizations and that they made aware of our EEO policy. I struck that. We are a public sector. We don't have labor organizations that we have to worry about, okay? And so a policy that works in tandem with EEO is affirmative action. We are not required to have an affirmative action plan. It's a good idea, and I've been talking to Ms. Cook about that. It's a good idea to identify if we have any deficiencies in our hiring and in our promotion and the like. We want to be that EEO organization. We're working. Understand that the affirmative action plan is not a policy. It's a plan. It's a document. It's about 180 pages long if it's done correctly, but it identifies those deficiencies. And so we may or may not do that. Kat and I are just talking about it as time goes on. One of the most important policies in this handbook, and it's why it's in the front, is anti-harassment. Okay, the anti-harassment policy is where most litigation will begin. And so 8 out of 10 employment matters that I handle are some type of discrimination, some type of harassment. It's unfortunate. Remember I said it's Civil Rights Act of 1964. We're still dealing with this. We are still dealing with this. So this is an important policy. The EEOC, which is the Equal Employment Opportunity Commission, just closed out their fiscal report, and they've had more than 200,000 claims filed against employers. This is a record number of claims. That's why this policy is important. There are 2 landmark cases out of the Supreme Court I'm not going to bore you with, but the bottom line to those cases is that we as an employer will be held just automatically liable. It's called vicarious liability. We will be held vicariously liable for the actions of our supervisors. Well, how can that be? We're not with our supervisors every day, but we have a policy that says if our supervisors are out there and they're engaging in sexual harassment or other types of harassment, we're responsible. But the Supreme Court gave us what's called an affirmative defense. In other words, something that we can do to prevent that, or at least try to prevent it, one of which is training every year. I don't know the last time we did training on sexual harassment. It's probably time in 2026, and we need to maybe think about it. And is it just rote? Is it just so we can check that box? No, it's to make our employees understand that it's not tolerated here, and there is a method to complain if you feel you've been a victim of any kind of harassment. The other part of the affirmative defense, including training, is to have a policy that tells employees where to complain. And I love Mr. Shacker to death, but I'm going to pick on him for a minute. What if my complaint is that Mr. Shacker is the harasser? Who do I complain to? You? Counsel? You don't want that, right? And I unfortunately had a client county one time. An employee went to a council member and the council member did nothing. And that's fatal to a claim. Fatal. To do nothing is fatal. You shouldn't be burdened with that. It shouldn't come your way. So we have a third-party reporting mechanism in our policy that says if you feel that perhaps it's one of counsel, again, no disrespect, or it's Mr. Shacker, the employee needs to know where to go. And so you can go to a county attorney or you can go to the employee assistance program, one or the other. And I often get questioned, well, how can we trust you? You get paid by the county too. Well, I do get paid by the county, but again, no disrespect, I answer to a higher level, okay? If somebody complains to me and I do nothing, they can report me to the disciplinary council of the bar and I could lose my license, and I'm not going to do that. And so, but at a minimum, employees need to understand that. They need to understand there is a mechanism in place, there is a way to complain, and not that we welcome bogus complaints, because we do not, but we want to know. We can't fix what we don't know, right? And so if this is going on, we need to know it. And so if the employee wants to go to CAT, they can go there. If they want to go, I would hopefully keep you all out of it. They want to go to the administrator, they can go to Mr. Shacker, they can come to me. They do not have to go to one person in particular, okay? They also do not have to put their complaint in writing. It's definitely helpful, But the EEOC says if we require that, it's coercion, it's intimidation, and that people they won't feel comfortable giving us a complaint. And so we don't require it. We ask that it be done, but we won't require it. And so we also do have some language in there for retaliation on false claims. Y'all, I see it all the time where we've got an employee, not Newberry, but in general, we have an employee who's probably on their third warning for tardiness or absenteeism. They have been put on a performance improvement plan, and they know the door is closing on them. And what do? They file an allegation of harassment against the boss, sexual harassment. He touched me inappropriately. He's been sending me inappropriate jokes, and the like. And then we come to find out during investigation, that's not true. That's not true. This employee was ready to be fired. No one is harassing them. And so there is a penalty for that. If we get a claim that's false, you could be subject to disciplinary action up to and including termination. And so there was a section in the policy handbook that said that as a general rule, employees cannot sue us for harassment unless they give us notice first. That's not necessarily true. The court doesn't require that. The Supreme Court didn't say EEOC says no, no. If you have duty, and so you don't have to get something in writing, the employee is not required to put you on notice. You are required to make sure harassment doesn't exist anyway. And so that's a pretty broad standard and a hard one to meet. But the training helps with that. The immediate response to any kind of complaint helps with that. And then certainly the policy helps with that.
Just for reference, I agree we need to have this training, but the employee needs to sign that they've had that training.
Absolutely. Yes, sir. They will sign an acknowledgement.
Right.
And to great segue to my next point, I think you have to periodically remind employees of the policy.
Right.
And what I would recommend is if we go into any kind of performance evaluations, when you do a performance eval, you have that employee's attention. Before you start the performance eval, give them a new copy, a fresh copy of the policy with a signature sheet, and tell them to refresh their memory. And they'll push back. They'll say, no, I've seen it. It's in the handbook. Just ask them to just refresh your memory and then sign the document. That means every year we've got that red flag that we can wave if we get a charge, that we have indeed notified employees. We have reminded them every single year in addition to the training.
Right.
So good point. And I know I feel like I'm jumping around on you. I hate to do that. The other thing I've included is workplace bullying. I think when your handbook was done last time, it wasn't a thing. We talk about workplace bullying. Oftentimes you hear the word bullying, you think of schoolyard kids, and it happens in work. It happens in everywhere. To me, the biggest proponent of bullying is Facebook. Okay, and so it happens, and we want employees to know that we're not going to tolerate that either. There were a lot of words that I took out of the employee handbook, words like entitled, words like accrued, words like fair, okay? Entitled, accrued, they're contractual, and we take them out, and instead of accrued, I use the word accumulation. Lawyers make their money on words, and so I know this sounds really petty to y'all, but it makes a difference. Entitled, the only thing our employees are entitled to is the paycheck at the end of the week. Everything else is a plus. And I don't mean that in a derogatory sense, but legally it is. The word fair, I don't know about you guys, but my mom always told me that life wasn't fair. And so when you leave fair in a document, in a policy, it sets up what's called a jury question. What's fair to Mr. Fulmer may not be fair to Mr. Cease. And so fair creates this question, all right? And so we don't want to create that question. And so we've taken the word fair out, even though we want to be fair, we want to be equitable, but we don't want to put it in the policy handbook, okay? Recruitment and selection process, I've scripted that. It really sounded more like a procedure than a policy, and there's a difference. The policy is, this is the law. The procedure is, how do we get there? Y'all set policy, HR and the administrator set procedure. And so if we wanted to do a procedures manual, we can do one. I've always felt that it's over the top. You don't need one. But I've taken a lot of the process out because the average employee doesn't care. They just want to know, what do I need to do to get time off? Or what do I need to do if I'm going to retire? That's all they want to know, okay? The other thing that I'm a big fan of is replacing the word probationary. Lots and lots of organizations say you're a probationary employee for 60 days, 6 months, however long it may be. So that means I'm a brand new employee and I'm already in trouble. I'm on probation already. And so, that's the HR person in me. I prefer the word introductory. It's softer, and it really is what they are. What if that introductory employee or probationary employee, they meet their 6 months? What are they now? What do they become? We have a tendency to say permanent employee, right? No one has permanent employment under at will. No one. Because if I had permanent employment, you couldn't fire me at will, and I couldn't quit at will. So there's no such thing as a permanent employee. They become a regular employee, regular full-time, okay? Again, wordsmithing, it sounds kind of silly, but I've taken a lot of those words out. Okay, termination. I moved termination. I've moved a lot of the policies around because the termination was in the front. And I thought, well, gosh, I'm just reading the handbook as a new employee and there's termination. That's one of the first policies. So we've moved that. The policy, the old policy had a requirement for notice if somebody resigns in order to use, or just in general. So let's say I'm an at-will employee and you're requiring me to give you a 2-week notice. I'm no longer at will, okay? At-will says I can quit at any time. I can go to lunch and come back and say, I'm out of here, right? So at-will works both ways. We cannot require a notice, except for the fact that we have PTO. We give annual leave. Remember I said employees are only entitled to the paycheck at the end of the week, right? So we provide PTO. It's a gift. That's gratuitous. That is not an entitlement. And so because we give it, we can put caveats on it. And the caveat that we put on it is that if you are going to resign, you have to give and work a 2-week notice, or we will not pay out the accumulated unused PTO. It helps with staffing. It helps with getting notice. And it encourages people to stay and clean up stuff. Now, we can waive that because there are often people we're glad to see their back walking out the door, okay? We won't lie about that. Sometimes we're thankful this person has resigned, but that's up to us. If the person had every intention of working out that 2-week period, we'd still have to pay out the accumulated time. But it's a good way to get folks to stay and work out a notice. And we will not approve any time off during that 2-week work notice, okay? We will not. Hours of work, this is a policy that's required by the Wage Payment Act of South Carolina. The policy mentions breaks in the old handbook. I'm going to dispel an urban myth. Work breaks are not required. We don't have to give you anything, nothing. And so long ago and far away when I was in HR, I worked for a construction company and I had 900 plus employees on my watch. And I would have to go through this explanation all the time, especially with new folks. And they would tell me, no, that's not true. If I work 4 hours, you have to give me a coffee break. And I would say to them, show me the law. Show me where it says that. Unless you have a collective bargaining agreement or a contract, there is no law that requires that. But is that smart? No. Okay, if we work people without coffee breaks, without a meal break, without any kind of respite, they get tired, they get careless, they get hurt. They also leave because they're not going to stay if they can't at least have a 15-minute coffee break or whatever. But the thing that I want to make sure that we advise employees is that these breaks are not required. And if we have citizen needs at your 10 o'clock coffee break, your coffee break may be at 11 because the citizens' needs are always going to come first. Okay, so that's the only reason I would address the breaks in here. And also under the Affordable Care Act, which is now several years old, we are required to provide an unlimited number of breaks, paid breaks for lactating mothers. Okay, so women that have to express their breast milk, we have to provide a private place that is not a bathroom, and we have to provide unlimited breaks for them. The other thing that I recommend, I had a client, the shop foreman came in and told the receptionist that the new coffee creamer was really, really good and wanted to know where she got it. Turns out that it was one of the women who was expressing her milk and put it in the fridge. And so the company had a policy, label the milk, please, because we don't need people drinking. Anyway, so we're going to require that too. But that's something that I'm not sure we have a break room for that. And it has to be private and not a bathroom. The law is crystal clear on that. Okay.
Can it be, and the only reason I bring this up is because, anyway.
You don't have to tell me why, just, yeah.
Can it be, like a supervisor's office if it can be locked?
Yes, as long as
Okay.
it's private and it's
Okay.
not a thoroughfare for people.
Right.
Yeah, yeah.
Okay, all right. Okay.
Yeah, the law is, initially when it came out, people were using bathrooms and then that's when they re-scripted that and said, no, but that would be fine.
Okay, all right.
Payment of wages, this is another policy that's required under Wage Payment Act. This is the opportunity that it's actually required, but it's an opportunity for us to tell employees how, what, where, and what they are being paid. This is required by law. We also made a change that includes the sentence, any changes to an employee's work hours or rate of pay must be made with written notice 7 days prior to the effective date. That is required by the law and it was not in the existing policy. Okay. And so we're going to talk about advance of wages a little bit. If I give you equipment, a laptop, a cell phone, a whatever, we want that back when you leave. And sometimes we don't get it back. And the one thing we cannot do is withhold somebody's final paycheck in order to pay for whatever it is we're not getting back. And so the advance of wages policy puts employees on notice and says, whatever we've given you in the course and scope of your work to do your job, we want back when you leave. It is an advance of your wage. And so if you do not return those things, we will deduct the value of those things from your final paycheck. With the caveat that we must always pay the employee federal minimum wage. So there's some math that has to go on here where we have to back into what we can get out of the check. So if the check is $400, whatever minimum wage is, it's $725 times however many hours they worked. Whatever is left is what we can take for the equipment, as long as it's the value. We can't overtake, but we always have to pay minimum wage. We can never, ever hold the entire paycheck or pay less than minimum wage. I had a client one time who fired someone and the employee was under an advance of wages policy, failed to return their pickup truck, and not only failed to return the pickup truck, failed to return to South Carolina with the pickup truck. So then you have a different, yeah, it's a different deal. Okay, you're not going to get that from the final paycheck, and we had to go to law enforcement and all of that. So the council has to make a decision, or the county has to make a decision as to, is this prudent to really pursue this money, depending on how much the equipment's worth. You know, if it's a piece of heavy equipment or a vehicle, sure. Cell phones, sometimes they're so inexpensive, it's not worth it. So just take a look at that. Overtime, we want to be very, very cautious with compensatory time. Compensatory time, as you well know, stands in the shoes of overtime. If our employee is not eligible for overtime, like an exempt employee, they don't get comp time. They do not get compensatory time. But you can gratuitously give somebody time off. So pick on Eric back there. Eric works all weekend on a project, an IT project, and he's exempt. And he has to come to work on Monday, even though he's worked all day on Saturday, all day on Sunday. Mr. Shacker says, Eric, you did such a great job with this project. Take Monday off. It's a paid day. That is gratuitous. There's no expectation of that because he does not have an expectation. He doesn't get overtime. He doesn't get comp time. Okay.
Comp time's illegal.
Comp time is legal for non-exempt. It's illegal in the private sector.
I get it all the time.
It is
Okay.
illegal in the private sector.
Okay.
There was a bill last year that was kind of bounced around Congress for a while to make it okay for private sector, and it got squashed. So, yeah. It would be nice because many employers look at me like I have six heads when I say, you can't use comp time. They're like, sure we can. No, you can't.
What's the
Oh.
purpose of the new law with
Call it something else.
overtime being
Untaxed.
taxed? Yes.
I think a lot of people are going to be surprised by that. There's a maximum. It's not every drop of overtime that you've worked. Yeah. I think it depends on your income. And then, so if your income's 150,000, you can deduct 25,000. Yeah. Yeah. So it wasn't as broad as it sounded. Yeah. And Social Security, the no tax on Social Security is the same way. So at holidays, I am a huge fan of not listing holidays. And here's why. They change. Okay. How many of you would have thought that 10 years ago, Juneteenth would have been a holiday, right? And so now it is. And so what we want to do is keep that flexibility and just state in the handbook that a list of holidays will be published at the beginning of the year. And that's something that then council can vote on and we can put to rest. And if there are any changes, if you want to add something, if you want to, I don't think you ever want to subtract a holiday. It doesn't go over real well. But I think it gives you some flexibility. We just have to make sure that we get it done before the end of the year. Annual leave, I think that this is something we can talk about at a different venue. It is very generous. And I will tell you that you have to keep in mind both annual leave, sick leave, and comp time, that these things go on your general ledger as a liability. Okay, it gets booked as a liability on your general ledger. And so let's say 2 years ago, I was making $10 an hour. I accumulate 360 hours, but I don't use it for 2 or 3 years. Now I'm making $20 an hour. That time that I've booked, that 360 hours, you're going to pay me at the new rate, not at the $10 when I accumulated that time. Okay. And so that starts to cost some money. It's a hidden cost that you're not aware of. Same thing with comp time. We should have maximums. The legal maximum is 240 for non-law enforcement and 480 for law enforcement, maximum accumulation of comp time. That's a lot of time. That's a lot of accumulation in addition to annual leave and so forth. And so same thing with comp time. If I'm $10 an hour when I've accumulated it, but when I use it, I'm now $20 an hour, you're paying me $20 an hour. Okay, so that's significant. I would recommend give some thought to the comp time maximums. Again, legal's 240, 480. You don't have to follow those numbers. You can lessen them. You can't increase them, but you can lessen them. I had a little municipality in South Carolina who they weren't paying any attention to the accumulations of the 3 police officers that they had. All 3 quit the same day. And this little town had to pay out thousands of hours. They had not paid any attention to the accumulations, and they were triple what the legal limits were. And we had to go cut a deal with Department of Labor and Wage and Hour. They didn't have the money. And so think about, I'm not suggesting that you cut it to, next to nothing, but 240 hours of comp time is a lot. Comp time's meant to provide time off because you worked hard and overtime, okay? And so instead of allowing it to accumulate, encourage folks to use it. So give that some thought. Sick leave, this is a policy that is also generous. We didn't have clear criteria on when employees were required to bring a doctor's note. We've changed a lot of that. Same thing with bereavement leave. I'm a huge fan of tightening that up. When people need bereavement leave, they really appreciate it. And so it's always nice to have, but there still should be guideposts on it, okay? And so what we're saying is funeral leave in the amount of 3 consecutive working days shall be granted and taken within 5 consecutive calendar days of the death, unless there are extenuating circumstances where the department head may grant additional time. So there's some workability there. It's not so hard and fast. Same thing for inclement weather. Apparently, we're supposed to get some, so we're going to be looking at that policy probably over the weekend. Understand that if we close the county down and say to the employee, you can't come to work, we're closed, we have to pay them. If it's their decision, they feel unsafe on the road, they can use a PTO day or take it as unpaid. But if we make the decision to close, we pay. Okay. Just want to make sure everybody understands that. Family and medical leave. We don't have enough time to go over family and medical leave. This is, it was a well-intended law that has just become abused. It is greatly abused. And so I have enhanced the policy. I think that the former HR director wanted it to just be a paragraph. You cannot do a paragraph on FMLA. You simply cannot, because there are too many facets of it. You've got FMLA, which is family and medical leave. For the, you get 12 weeks of unpaid leave. It's 26 in some circumstances, most of which are military. But the 12 weeks can be one shot, it can be intermittent, or it can be a week at a time, okay? It is a record-keeping nightmare, and it's abused, as I said. Now, the former policy automatically, when you got to the end of your 12 weeks, granted an additional 14. For no reason. Just when you get to 12, let us know and we'll give you 14 more. And so we don't want to do that. We don't want to encourage anybody to come back to work too soon, but we certainly don't want to encourage 14 weeks.
Would that come out your sick leave?
No, it was just 14 more weeks of FMLA.
But it's unpaid.
It's unpaid, but however,
Still.
we're going to run them concurrent. And so if you've got accumulated unused PTO and FMLA, you're going to run them together until you run out of paid. And so then you still have your 12 weeks. If you've got 10 weeks of paid leave, then the last 2 are unpaid. So it's better that way, so you don't have somebody taking 12 weeks and then coming back and taking 10 more. Yeah. But at the end of the 12 weeks, we don't want to automatically terminate anybody either. What we need to do at that point is the administrator, HR, perhaps myself, needs to sit down and analyze the situation to see if we have an Americans with Disabilities Act issue. If we do, that requires a reasonable accommodation for a serious illness or other situation, injury. However, we want to make sure that if this is an ADA situation, a reasonable accommodation is more FMLA. So if the employee is already coming up on 12 weeks, at the 10th week, we want to really start that analysis to see if we've got an ADA issue and is additional time under FMLA a reasonable accommodation so we can make sure we address the ADA. Am I making sense? It's kind of convoluted. All right. We do. Bottom line is we don't want to automatically terminate somebody at the 12-week period. Okay. Travel, I'm not going to go over that. I changed that a little bit. Same thing with county vehicles. I eliminated some policies. The workers' compensation benefits, I feel it was a pretty light policy. We've addressed light duty. I'm a firm believer in light duty, especially having come from construction. There's always something you can do, always. And if you leave employees linger out on workers' comp, they're sitting at home, they're watching television. Anybody been home lately during the day watching TV? It's all lawyers, right? Injured at work? We got you covered.
Call all 9.
We don't need them at home watching that stuff. There was a policy in the old handbook called attitude and common courtesy. I took that out. That made no sense to me. I always tell people I have an attitude. It's a good attitude, but I have an attitude. Okay, so I took that out. It just didn't sound right. Personnel records. I want to address this. We're almost out of time, but I think I can get this done. Personnel records. It is really important for everybody to understand, including our employees, that we have personnel records. that are county records that just happen to have an employee's name on it. They belong to the county. They are not employee files, okay? They are ours. They are official government records. And so if an employee wants to see what's in their file, they can make an appointment with HR. They can look through it. They cannot take anything out. And if they want to put something in, they have to get permission. And if I get a commendation or an award certificate, I want that in there. I want that in my file. But I have to ask. I can't just automatically put it in there. But it's important for employees to know that it's not their file. This happens a lot when they get fired. When an employee gets fired, I want my file. Well, it's not your file. And unless I get a subpoena, you're not getting it.
You can get
Even if-
copies of it or anything.
No, nothing. Not even and you can submit a FOIA if you want, and then Andrew's going to redact it. And so you're going to get a piece of paper with a lot of black lines on it. Because there's so much personal information in there, we're just not going to hand that over. So, job references. So South Carolina has a law that says if you give an honest reference, you won't be sued for defamation. I've never seen that work. It's a state law, and I've never seen it work. And so I always recommend neutral reference, name, rank, and serial number. It's all you need. However, we cannot tell other employees that they can't speak on behalf of somebody. So if Andrew leaves us and he wants to get Eric to give him a reference, we can't say to Eric, you can't. But what we can say to Eric is make sure they understand you're speaking on behalf of yourself and not the county, okay? We also, internet, you can see that we've expanded the electronic policies, and certainly you have to get the blessing of Eric, because a lot of it was way out of my wheelhouse. But one thing that I did want to put in there was that we reserve the right to remotely wipe any and all electronic devices. And we're not responsible for any personal data that's stored on our devices. This is just on ours. So if somebody has a laptop and it has our budget on it and they lose it, or someone breaks into their car and steals it, we want to be able to remotely wipe that information, okay? Substance abuse, I changed some of that because we do have some different substances out there that we didn't have before. Vaping is also an issue. I don't know if you know this or not, but if we're going to stop smoking within the vicinity of any county building, we need to stop vaping as well. The reason is not just because they're smoking too, but because there are cartridges for vapes that are marijuana. And so you just don't vape on county property. So employee conduct, I think we talked about that. Grievance procedure, this does have a lot of process and procedure in it, but I believe that it has to, because this is something that if I'm going to file a grievance, I want to see what I have to do. What are the steps? Who do I have to go to? And so we fleshed that out. There were a lot of attachments, and the ordinances were in the old handbook. They're gone. There's a COBRA notification. Y'all probably know that when you leave a company, when you leave a job, you get a notice of COBRA rights. Okay. Well, in 2008, COBRA changed, and the requirement is now that we have to tell employees up front what their COBRA rights are and not wait until they leave. Putting it in the handbook sort of alleviates the thought process that HR has to go through. Oh my gosh, how many documents do I have to give this employee? It's already in the handbook. They don't have to worry about it. Okay, so employees are coming in the door are notified of their COBRA rights as they're required with the changes in 2008. Same thing with the health insurance marketplace. That goes back to ACA, Affordable Care Act. We have to tell our employees what their rights are and how to access affordable care if they decline our insurance. That's in the handbook too. Paternity leave, there was a policy in our old handbook for paternity leave. I took it out. It's covered under FMLA. And so FMLA is not just for women having babies, it's for men who are becoming fathers and want paternity leave. It's called bonding time, and they're entitled to that. So it's already under FMLA. And the last policy that I added is called salary basis. This was from 2008 also. It was an amendment to the Fair Labor Standards Act that requires us to tell exempt employees what their rights are. So if they feel that things have been deducted erroneously from their paycheck, then they have the right to file a complaint within the county and then to go to Wage and Hour if the county doesn't resolve the complaint. So that is a real broad brush, really fast. I know it's a lot, sorry. It's a lot. But if you can take the time to look at the policies that maybe interest you, that you have maybe had to deal with, you've got complaints from, whatever the case may be, and in 2 weeks, or 2 meetings rather, if we can revisit those, that would be a wonderful thing.
And looks like all the changes are highlighted pretty much. So
Yes, sir, I tried to do that.
I think, we all take a little time, look over it, and we'll be ready in the next meeting or two.
Yes, 2
Make the
meetings.
changes.
Okay, thank you.
Thank
And if you have changes in the meantime that you want me to make before the meeting, I'm happy to do that and then just create a new red line.
Be great.
Okay.
Thank you.
All right, item number 2 is an executive session. Legal matters, receipt of legal advice regarding matter relating to planning, zoning, and local floodplain management pursuant to South Carolina Code of Law, section 30-4-70A2. Do I have a motion that we go into executive session? Got a motion by Vice Chair, second by Councilman Smith. Any discussion? All in favor? It is unanimous. We will be in executive session very briefly.
I made you a copy of it, and we kept a copy. It's that stuff.
Oh, okay, yeah, so they served me,
Oh, they served you too?
yeah, they stuck it in my mailbox, that is not,
No.
it's not right.
Look, this little guy comes and tells him that he's gonna sue you. And then
Hit you about the 20
Yeah,
crowd out.
yeah, tough, isn't it?
Perfect, awesome.
All right. County Council went into executive session for the aforementioned reasons. No action was taken. Do I have a motion that we come out of executive session?
So move.
By Councilman Fulmer, second by Councilman Reader. Any discussion? All in favor? It is unanimous. Do I have a motion that we
Adjourn.
adjourn? Motion by Vice Chair, second by Councilman Scurry. Any discussion? All in favor? It is unanimous. We are adjourned from our work session. And I'd like to call the 6 o'clock meeting of County Council to order with the invocation and pledge by Councilman Smith.
Thank you. Dear Heavenly Father, oh Lord, we thank you for this day you bestowed upon us. Oh Lord, be with us and guide us in our decision makings. Give us strength and wisdom. Oh Lord, be with our first responders as they keep us safe and oversee them. Oh Lord, please bring calm as the storm approaches us. Oh Lord, we pray prayer in your name. Amen. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Oh, thank you all for being out tonight. Glad to have you, before the storm hits. Hopefully it doesn't hit. First item is the adoption of the consent agenda. We'll take these as one, if I hear no objection. Hearing none. Item A, Newberry County Council Work Session Minutes, January 7th, 2026. Newberry County Council Meeting Minutes, January 7th, 2026. Motion to accept the agenda. Motion by Councilman Smith, second by Councilman Scurry. Any discussion? All in favor? It is unanimous. I think. Is Mr. Johnson on?
Derek is caught on. I don't see him connected right now.
Okay. All right. Are there any additions or deletions to the agenda? Do we have a motion to accept the agenda as presented? Motion by Vice Chair, second by Councilman Reader. Any discussion? All in favor? Councilman Johnson? It is unanimous. Item number 3 is special recognition. And I will turn it over to Mr. Shacker. That's part of our meeting.
Yes, sir. Thank you, Mr. Chairman, members of council. Good evening, everybody. This is a recognition that we like to do our second meeting of each month, where we recognize employees for longevity and also for retirements. And so we've got 3 employees here with us tonight, one with 5 years, one with 10, one with almost 33 years, and then one retiring. And I will call them up and we'll do a little recognition. I'd like to tell you a little bit about them. And so our first is Daniel Colon. He's in the sheriff's office. Yes, sir. Thanks so much for being here.
Yes, sir. Thank you.
Did I just drop something? Please join me here. Daniel, it's a pleasure to recognize you for 5 years of service. Daniel, as you can see, is in the sheriff's office, and he actually started with us several years ago at the detention center. Yes. And then you took a little sabbatical and went to I believe the city. Yes, sir. It's an officer. You live here in town. Yes, sir. And then came back to work. He came to the census. He came back to the county and worked in the patrol division. And I understand from the sheriff management team out of the sheriff's department how much value there, hardworking, loyal, and you don't say that when you're asked to do something or asked to go. You're always happy to do that. I'm sure appreciative there. And that's why it's such a pleasure for me on behalf of the county council and our management team and the sheriff and his management team to recognize you for your 5 years of service. With that, yes, thank you so much. Yes, sir. Our next employee has 10 years with us, that's David Brown. Thank you. Thanks so much for coming. Yes, sir. Appreciate that.
Yes, sir.
Well, David is also the sheriff's office, you can see, and came to work for us, and kind of like Daniel, he took a little break, and then came back to us. He started, you were in the patrol division, right?
Yes.
Took a little break, came back to us, and, then, went into SRO.
Yes.
And SRO, you know, we use a lot of acronyms together, that's school resource officers, and I don't think we can overstate how important our SRO program is, because they are the, public servants and officers that keep our students safe, our faculty safe, our staff safe in our schools. And, you know, a key to the role, and David exhibits this, is developing trust. Trust is very important. And what I understand is the students love you, man.
Yes,
And,
sir.
they respect you, and they also look at you as a role model. And so you got that rapport with them. That's what makes you so effective in that job. And I guess that's why it's such a pleasure, county council, me and the management team here to recognize you and to thank you. Yes, sir. Appreciate all your work. Yes, sir. Last but not least, Ms. Carol Wiley. Thank you so much for coming. So, like I mentioned, Carol has almost 33 years of service. I think in February she's 33 years, right? Yeah, so she's got 32 years and 11 months and however many days. Well, Carol has spent that entire time in the clerk's office. So she came to work from county back in 1993, probably for a part-time district. And then you spent 2 years in that role, and you were promoted, and that was in the real estate division. Yeah. And then you were promoted 2 years later to clerk typist 2, where you went over to bank 4. And you spent most of your time since there at bank 4, right? All that time. Yeah, so 30 years or 30 plus years. And so ultimately she was promoted to her current position as deputy clerk in bank 4. And Carol's, I think you can see, is one of the nicest people you can meet. She's so pleasant to deal with. What I understand from Beth and from your colleagues is how much you are loved by them and you are loved by the customers that rely on you for assistance. So, yeah, the right. But you're going to be great with this to Newberry County. I know you're going to be great with this to that department. And so it's really like an honor for me to recognize you and to thank you. I used to work for her husband. He was a city councilman back in the day when I was at the city. So it's almost full circle. So I want to present you with a certificate, and I want to thank you for your years of service. And we wish you all the best.
Thank you. Thank you. Daniel, David, and Ms. Carroll, we certainly appreciate all that y'all do for Newberry County, are doing and have done.
Thank you.
Certainly appreciate it. All of our county employees, y'all make everything work for us. All right, item number 4, ordinance number 12-01-2025, an ordinance acting on request to amend the official zoning map established pursuant to zoning ordinance number 12-24-01 as revised and amended by zoning ordinance number 6-11-16 and codified in chapter 153 of the Newberry County Code of Ordinances establishing zoning classification and district so as to rezone one real estate parcel totaling 0.80 acres designated as TMS number 640-88 from RS single family to R2 rural. This is the 3rd reading. No changes, correct?
Yes, sir. No changes.
All right, do I have a motion to speak third reading? I'll make that motion. All right, motion by Vice Chair, second by Councilman Reader. Any discussion? All in favor?
Yes.
It is unanimous. Item number 5, ordinance number 01-01-2026. An ordinance to amend the text of the official zoning ordinance of Newberry County, South Carolina, as codified in chapter 153 of the Code of Ordinances of Newberry County, South Carolina, by amending section 153.033 fences and walls, section 153.168 setback from the lake shore, section 153.170 structures and projections into required yards and right of ways, and section 153.231 definitions. This is the first reading. Do we have any explanation of this?
I'll be glad to give you an explanation. So currently in the zoning ordinance, fences are allowed within setbacks. But we felt like that, it would be good to have some clarifying language inserted to the ordinance, in our zoning ordinance into several sections, making it clear that it's both fences and walls and the setbacks that fences and walls are permitted within. And so just kind of walking you through it, because there's several sections, like you just mentioned, in the title of the ordinance that are proposed to be amended. And you'll see in your copy of the ordinance that the changes are highlighted in yellow. Section 33, fences and walls, we're proposing the addition of subsection 6, that fences and walls shall be allowed within the setback areas identified in section 170 of the ordinance. And that's existing language for the most part. The only change in 170 related to setbacks is that in the case of fences and walls and security gates and paths and similar structures like that, that it's clear that those can be located in required setbacks or yards, including the lakeshore setback. Because, we've got a special setback that applies both to Lake Murray and to Lake Greenwood, and this would be the rear yard setback. So that's the amendment to 170, but otherwise, that section 170 referenced initially is intact in its current, or proposed to be intact in its current form. Then when you move into section 168, we wanted to make it clear in the setback from the lake shore that there's an exception for fences and walls. So obviously, structures like accessory structures or homes would not be an exception, but fences would, or are proposed to be. And then when you go down to the proposed amendments to section 231, which are definitions, we wanted it, instead of just being fences, to be fences and walls. And so that language is proposed to be changed under the definition structure. So fences are struck and then fences and walls are added.
Very
So
good.
again, it's just really just clarifications.
All right, do I have a motion to speak first reading? Motion by Councilman Smith. Second by Councilman Scurry. Any discussion? All in favor? Councilman Johnson?
Yes, I concur.
It is unanimous. Item number 6, consideration and approval of bids for construction of Newberry Museum roof repairs, a 2022 CPST project, bid number 2025-18. Shacker?
Yes, sir. So this is one of our CPST projects. We have 12 of them. One of them is the museum, which is located in the old post office there on Friend Street, at the corner of Friend and College. The scope of the project was twofold. One was heating and air replacement, and y'all awarded that contract, and those units have already been replaced. So that's been accomplished. The other component of the project was replacement of the roof. And, that building is one of the most attractive buildings that we have in downtown Newberry. You could probably picture it maybe in your head. If not, I'll describe it. It has barrel vault clay tiles, just a really beautiful structure. And it has a flat area on top of the roof with an internal gutter system. And those internal gutters and downspouts are a little bit of a problem. Historically, what we've been doing for the last 100 years is taking water from outside the building, passing it through the building, and then sending it back out the building. And so the proposal here is to not only replace the clay tiles, which is a challenging endeavor. I mean, you can't just remove them all at one time or the roof will it's a 100-plus-year-old roof, it'll rebound on you. But the other thing is you've got to cover over the existing internal gutters so that they're no longer fed. And then we've got to cap the sort of the defining feature. It's almost like a dormer on top of the building. And there used to be a flagpole there, the post office flew an American flag, just centered on the building. And so we have bid the roof job, and you see a bid tab in front of you that was part of your packet. And the low bid, which we would recommend, and the architect recommends you award to, is to Benton Roofing for $369,472. They were the lowest responsive and responsible bidder, and their bid is within budget. We would recommend at this point in time against taking the alternate, and the alternate was for not roof deck repair and replacement, unforeseen. It was for soffits and fascia, and we would just recommend that be tackled separately at a later date. And we go directly to a contractor who specializes in doing that work. We didn't feel like we got very favorable pricing for that, and instead of recommending to y'all that a general contractor's profit and overhead be put on top of the cost of those repairs, that we look at possibly doing that later. This also ensures that we can accomplish the project within budget unless we ran into a major issue with the roof deck that we don't believe we'll run into. So.
Good. Have a motion to approve.
I'll make that motion.
Motion by Vice Chair, second by Councilman Reader. Any discussion?
Where's the project beginning?
They'll mobilize pretty quickly. I mean, we'll do a pre-construction
Okay.
meeting, but yeah, this spring,
Okay,
we
great.
can accomplish it. Yeah. And one thing I didn't mention too, because this is important, and the city's Board of Architectural Review approved this, is the addition. We're losing the internal gutters. We will be putting up external gutters, and they will be copper, which is period significant. It's sensitive to the character of the building, and so there will be copper gutters and downspouts.
Okay, great.
That's right. That is in the roof scope that y'all are approving. Yeah. And then there'll be a copper top that is put onto the
Flat part.
Yeah. The
Okay,
flat
great.
roof up there. Yeah.
And we're not replacing all the tiles, just the ones that are damaged and need to be replaced, correct?
That's right. Although it's more significant than I realized. Yeah. It's a large number of tiles that are being replaced. Yeah. And they'll very carefully do that in sections so that we don't have a major issue with the structure, bowing on us. Yeah.
Thank you.
Yep. Yes, sir.
Any further discussion?
And Mr. Shacker, could you, I know you said it, but I'd like to hear it again, that this was competitive bid. There were multiple responders. This is the low bid.
Yes, sir. We had a good response to the bid, and this is the lowest responsive and responsible bidder.
All right. All in favor? Johnson? Might be in a bad spot.
I am in favor.
All right. All right. It is unanimous. All right, item number 7, do we have any appointments? Seeing none. Public comment. Mr. Gary Jens? Come on up, state your name and where you live.
My name is Gary Ginn. I actually live in Blythewood, but I own a house at 1203 Newberry Shores Drive in Prosperity, South Carolina, 29127. I'm in Mr. Fulmer's district. Thank you for hearing me. I have several questions because I didn't get to see the proposed changes, number 5, because I didn't have a copy of it or anything. But I would like to submit a proposal is that I've had my house at Lake Murray for over 45 years. I've lived up there for 11 months. I don't see any reason why that my view from sitting on my porch or looking out of my house that has 4 sides looking out to the lake, if fences are allowed to be put on the 360 contour, then that basically is like putting horse blinders on me. So I don't know exactly what this change is, but if Newberry County allows fences to go down to the property, to the 360 contour line, then there's a lot of people, even in my neighborhood in Newberry Shores and around the lake, that the angle at which houses have been built over the period of 45 and 50 years, if you put fences all the way to the edge there, then nobody's going to be able to see the lake as they have for these years. And so I would hope that y'all would take great strides in looking out for us that have enjoyed the lake and the view of the lake, of coves and the big water for the lake for 45 years. We can't move our houses.
Understood.
Does that make sense? So if you could, somebody provide me with a copy of those changes, I'd appreciate it.
I think we can probably make that happen.
Absolutely.
Does that ordinance specify what type of fence?
No, it doesn't. No, there are limits in the ordinance to fences in terms of the finished side, needing to face outward unless both sides are finished, and the height. They're just those basic requirements, which are already in there.
See Mr. Shacker, and he'll get you.
Absolutely.
All right, that's all we had signed up for public comments. Comments from the county administrator.
Yes, sir. I'll just, so our next, of course, y'all just made the award, appreciate that, on the museum roof. And so, we'll get to work on that like we discussed. The next one will be the public safety complex. And so that's looking like a bid in March, and had a really good meeting yesterday afternoon. Probably went about 2 hours. We're at 65% design. So they're pulling it together quickly, and have the engineers on a tight time frame to turn the documents around. So that's really good. I also wanted to mention to y'all, there's been a lot in the news here over the last couple of days about the approaching winter weather, and just wanted to reassure y'all that I think the staff's doing a good job of preparing for the event. We've got a weather briefing tomorrow at the EOC, and then I know a group of us as a staff will get together after that and just talk about the game plan and make sure everyone's on the same page. But I did have extensive conversations today with Josh Rowe, our Public Works Director. I know that's always a concern, roads and particularly bridges, when we have those kind of low temps and freezing rain. We're almost fully staffed. We're down 1 employee, so we've got our full complement of employees that are available, and it will be all hands on deck. We'll have all 4 motor graders operating. DOT was kind enough to provide us with smooth blades for our motor graders instead of the toothed blades that we use for gravel roads. We've got an agreement with them where we scrape 34 from 76 to 176, and of course we'll continue to do that, which will be 2 of our graders. The other 2, the department are going to strategically locate out in the county so that we're able to address the priority priority would be connecting and arterial roads that are in the county system. But to the degree we can, we'll also address other roads that are in the county system. DOT was also kind enough to furnish us with 60 tons of salt. So that was approved by the district office, and we were taking delivery of that, I believe, tomorrow morning, if I'm remembering correctly. So we'll have that 60 tons. Josh had told me 20 to 40 at a minimum is what we need. So, but really, we need more like what they're giving us. So that's good. Got the sand spreaders going, so we'll spread that and, do the best we can to be responsive. I know he's got a plan for ensuring that the phones are managed, and also for the employees to have the equipment and take-home vehicles they need. So if we have to, we can go pick employees up that have issues getting in. So we will have folks out and working, and we'll just prepare for the worst and hope for the best.
Very good.
We
Thank
will
you.
get a briefing tomorrow after the briefing.
Yes, absolutely.
All right, any comments from any council?
I'd like to make a comment. Observation I made this morning, I was coming back from Columbia, and I just wanted to give a shout out to the sheriff's department. The deputy was parked on the side of the road where some water had come across the road, and of course, it was a solid sheet of ice, so he had his lights on warning, and I don't know if somebody called it in or he on patrol, he noticed it, but he was sitting there warning everybody that there was if you would have hit that thing, you could and not slow down, you could have gone off the road and crashed. So I just appreciate that awareness and keeping the citizens of Newberry County safe.
Very good, very good. Good looking
And
out.
also want to comment on the MLK weekend. It was a great weekend. Even though we didn't have the parade on Sunday due to the weather, Monday turned out very well. Church was packed inside and outside. So the MLK holiday was very rewarding to everybody.
Very good. I also want to just let everybody know to be careful during the potential oncoming weather. Be prepared for the worst, coming from the power side. Be prepared for an extended outages if possible, that could take place because we have to have safety for our guys as well. We're not gonna put anybody out on the roads to put power back on when the roads aren't safe to do so. So make sure everyone prepares themselves for what could potentially be an extended outage. Hopefully not, but just be prepared. Stay safe and call us if you need anything. That's all I got.
Yeah, I apologize for chiming in here, but the storm definitely brings to light things we need to be aware of. DOT will be out starting tomorrow, starting to do some pre-treatment on bridges, interstate areas within the county. So, certainly be mindful of those trucks. If they're spreading sand, salt, stay back away from them. Don't get right up close to them. Don't tailgate behind them because you never know when they're going to stop and start spreading. And if you're right up behind them, they're not going to be able to see you. So if you see them out on the road, I encourage citizens to stay back and give them plenty of room. They'll probably also be putting out some brine, which is a liquid. So anyway, just be mindful of that. If you see it, be mindful the roadway may be a little wet for a little bit. But anyway, the other thing is if we do have power outages, roadways are bad, and then the power does go out. Citizens, please check on your neighbors, check on your elderly. Be mindful of that and look out for folks. Our citizens are really good about doing that, but we need to look out for each other. We are each other's brother.
Absolutely.
Certainly take time to do that. So, and that's all I got.
Stay off the roads if at all possible. Keep yourself safe and watch out for your neighbors. Any further comments? All right, hearing none. Item number 11, future meetings. Newberry County Council Work Session, February 4th at 5 p.m. has been canceled. Newberry County Council, February 4th at 6 p.m. Public Safety and Courts Committee, February 9th at 5 PM. President's Day, February 16th, offices closed. Newberry County Council Work Session, February 18th at 5 PM. Is up in the air. Newberry County Council, February 18th at 6 PM. Do I have a motion to adjourn? Motion by Councilman Smith, second by Councilman Scurry. Any discussion? All in favor?
Yes.
Yeah, that is unanimous. We are adjourned.
When is this supposed to start? I'm trying to find record or something or other.
Yeah, it was like, I think Saturday evening, unless, let me see if it's gotten pushed back. Oh, thank you, yeah.